On the record in the matter 25 CF 158, State of Wisconsin versus Luke Beechler. The state appears through Assistant District Attorney Jose Vila in person. Mr. Beechler appears in person with counsel Joel Feliski.
This courtroom session starts like routine procedure, but don't let that fool you. Behind the formal language and scheduling talk lies a case that escalates into one of the most serious repeat offenses the court can handle. We're about to witness negotiations, plea deals, and ultimately a sentencing that could change a man's life forever. Pay close attention to how the tone shifts from administrative to intensely personal when the judge confronts the reality of a 10th OWI offense. How many chances should the system give before consequences become irreversible?
We're set today in this matter for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. I've received discovery from the state. It is quite voluminous. It consists of 36 gigabytes of data. I have not had an opportunity to fully review all of that. In addition, there are certain documents within that discovery that the defense has stipulated cannot be provided as copies due to sensitive information to Mr. Beechler. My point being, Your Honor, I'm just asking for a status conference to review that discovery in full and discuss with my client. I will also let the court know that I received an email from the state this morning. They don't yet have an offer on this case. They are waiting for further input from the victim.
Okay, and this is a Mr. Schmidt case?
That is correct, Your Honor.
Okay. Is Mr. Beechler contemplating, or as part of the agreement, can somebody tell me the IDIP program?
I think that certainly could be an option, Your Honor. Again, the state hasn't given me an offer yet.
Because if that's the case, you're gonna have to pry him on that and say, okay, I understand no offer, but the IDIP program, just see if that would come into play at all, because that's gonna take 4 months to complete.
Certainly, Your Honor.
And this is already from November. So I'm gonna have a shorter turnaround with regards to status. Can you do February 20? Let's just say, can you do February 24th at 2?
Unfortunately, I have hearings in Sawyer County at that time, Your Honor.
February 27th at 10:30?
That will work, Your Honor.
All right, February 27th at 10:30. We will see you then. Just for Mr. Beechler and
I got one.
okay. Come and get an IDIP program, then you can look at it, because that could go a long way. I mean, it did in my last case, was for an OWI second injury. I don't know. Talk to Mr. Schmidt. We will go on the record in the matter 25 CF 125, State of Wisconsin versus Charles Kurkowski. You're free to go.
Okay. Thank you.
The state appears through Jose Vila, Assistant District Attorney. We have Joel Feliski, Defense Counsel in person. Mr. Kurkowski appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. I believe the parties have reached an agreement to resolve this matter. The agreement would involve Mr. Kurkowski pleading to the count of burglary and the complaints with the habitual criminality repeater dropped. There would be an agreement between the parties for an argued sentence. The state would be capped at 3 years, recommending initial confinement. That is my understanding of the agreement. I believe we just need a plea and sentencing set.
And this is a Mr. Schmidt case.
That is correct, Your Honor.
And so no PSI, just,
No PSI, Your Honor.
and you said 3 stated is capped. Is it 3 years initial, or is
3 years initial confinement, Your Honor.
what they're capped at?
Yes, Your Honor.
Okay. Okay, are we gonna have victims that make statements?
There's a chance.
There's a chance. And do you have an idea of how many Potentially.
Who would be at the most?
I could do February 24th at 11.
That will work for my calendar, Your Honor.
February 24th at 11, block a whole hour. All right, thank you. We are adjourned. For 25 CF 138, State of Wisconsin versus Jennifer Rawls, the state appears through Assistant District Attorney Jose Vila in person. Ms. Rawls appears by video conferencing. We have her counsel, Joel Feliski, in person. We're set for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. I believe the parties have reached an agreement in this matter to resolve. The agreement would be for Ms. Rawls. I apologize, I'm just pulling up the original offer now. My apologies, there we are. The agreement would be for Ms. Rawls to enter a plea to misdemeanor theft in the 25 CF 138 file. The felony bail jumping count would be dismissed and read in. Stipulation to the restitution of $46.36. A joint agreement between the parties for 10 days jail. I believe that all we need to do is schedule for a plea and sentencing. Your Honor, I would request that this would be set out some ways to allow Ms. Rawls time to gather the funds needed for the ankle monitor program.
And that's not a given, you know. It's
Of
an
course, Your Honor.
argument you need.
Yes, Your Honor.
Especially with the crime of this nature and not the OWIs. All right. I could do March 9th at 1:30.
Unfortunately, I have a preliminary hearing at that time in Sawyer County, Your Honor.
March 13th at 10:30.
That will work, Your Honor.
All right, March 13th at 10:30. We will see you then in person. We are adjourned. There we go. There's Mr. Hess. Okay. All righty. And we have Mr. Quinn. That's at 2:15. Okay, so you have the plea questionnaire waiver of rights form.
Yes, Your Honor.
Please come forward.
Yes, Your Honor.
Thank you.
And Mr. Hess, can you hear me?
Yes.
Oh, to clarify, sir, an earlier question, the traffic tickets are going to be dismissed and read in.
Okay, thank you.
We will go on the record in the matters 25 CF 110, 25 TR 630, and 631, State of Wisconsin versus Daniel Hess. The state appears through Assistant District Attorney Kevin, yeah,
Just a logistic matter. I believe your microphone is off.
thank you. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski, Defense Counsel in person. Mr. Hess appears by video conferencing in custody. I believe he's in Dodge Correctional Facility. We're set today in this matter for a plea and sentencing. Mr. Hess, you appear by video conferencing from Dodge. Do you understand that you do have a right to be here in person?
Yes, I do.
And are you asking the court to allow you to enter a plea and be sentenced by video conferencing?
Yes.
All right. Do you understand that at any time you have any questions or concerns and you need to speak with your attorney, I will send him into Zoom and give you a confidential breakout session, okay?
Okay, thank you.
If at any time you can't hear something or see something, please let me know so that I can make sure that you've heard and you understand everything, all right?
Yes.
All right, okay. So what is the agreement that's been reached, Mr. Feliski?
Thank you, Your Honor. The parties have reached an agreement here for Mr. Hess to plead to count one of the complaints. Count two, as I understand it, will be dismissed as a matter of law. A joint recommendation between the parties for statutory minimums on sentencing, which for an OWI of this category would be no less than 4 years of initial confinement.
All right. And that's the agreement that you have reached, Mr. Hess?
Yes.
Okay. All right. So Mr. Hess, I have in front of me a plea questionnaire waiver of rights form. Did your attorney go over that document with you?
Yes, he did.
Did he essentially read it to you word for word?
Yes.
And did you understand everything completely?
Yes, Your Honor.
If you did not understand something, did you ask your attorney to explain it?
Yes, I did.
And he did so.
Yes.
You are pleading guilty to one count of operating a motor vehicle while under the influence, 10th and subsequent offense. Is that correct?
Yes, Your Honor.
And you did not sign this document because you are currently incarcerated and Mr. Feliski is here, and it's sometimes difficult with prison, mail, etc. But did you give him, or are you giving the court a statement on the record that if you had the ability to sign it, you would?
Yes.
You are pleading guilty again to the OWI 10th offense and well, under the influence. You're 57 years old. You have 12 years of schooling. You can read, write. You understand the English language. Is that correct?
Yes, Your Honor.
Mr. Feliski, did you thoroughly go over this document with Mr. Hess?
I did, Your Honor.
Did you essentially read it word for word?
I did, Your Honor.
And at the time, do you believe he understood everything?
I did, Your Honor.
Did you fully explain to him what the state would need to prove guilt beyond a reasonable doubt for an OWI 10th and subsequent?
I did, Your Honor.
Did you go over with him the mandatory minimums as well as the maximum possible penalties he may face?
I did, Your Honor.
You are, and Mr. Hess, you are not receiving any treatment for any mental health illnesses or disorders and no alcohol, drugs, or medications. Is that correct?
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and Mr. Mr. Feliski went over those rights with you. I'm going to briefly go over them with you again. Do you understand that you would be giving up your right to a trial? You'd be giving up your right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You'd be giving up the right to testify on your own behalf or the right to remain silent and not have your silence used against you. You would also be giving up the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. You would also be giving up the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all those rights you're giving up?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you also understand that here the state would have to prove for count one, operating a motor vehicle while under the influence, 10th and subsequent offense on or around August 4th, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a 10th countable offense. Do you understand what the state would have to prove?
Yes, Your Honor.
You understand this is a Class E felony, and upon conviction, you face a fine of not more than $50,000 or imprisonment of not more than 15 years or both, and that because of the nature and the gravity of this offense, and that you have been, you have nine or less countable, or 9 countable offenses, and this would be 10th or subsequent offense, that the court shall impose a bifurcated sentence of a confinement portion of not less than 4 years of initial confinement. Do you understand that?
Yes, Your Honor.
Do you understand that there is an agreement here that's been reached in which the parties are going to recommend to the court the minimum maximum penalty, the minimum, confinement that is required and mandated?
Yes, Your Honor.
Do you understand that as judge, I'm not bound to follow that minimum mandatory requirement, and I could sentence you all the way up to the maximum if I thought it was appropriate? Do you understand that?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes, I did.
In particular, there is a section called the probable cause section in which it basically says what happened and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant in this county and this state?
Yes, Your Honor.
Are you admitting here today that it is your 10th or subsequent countable offense?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Mr. Flisky, may the court use the probable cause section of the criminal complaint along with the statements made by Mr. Hess to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Hess, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes, he has.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes, he has.
Has he discussed with you the discovery and the evidence in this case?
Yes, Your Honor.
Has he discussed with you whether or not you have a defense or a lack of defense in this case?
Yes, he has.
Have you discussed with him any facts and any and all facts that you know to exist about this case?
Yes, Your Honor.
Have you discussed with him any of your ideas as it relates to this case?
Yes.
Are you satisfied with his services?
Yes, I am.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1, OWI 10th or more, a class E felony, how do you wish to plead?
I wish to plead guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
My apologies, Your Honor. I might have missed it. So the joint recommendation, I'm just filling in my apologies. So joint recommendation is 4 years initial confinement, no agreement on extended supervision, just the confinement.
I believe it was the statutory minimums.
Okay. Just wanted to clarify, Your Honor. Thank you, Judge. This is a case where dispatch received a call about an unconscious driver that was passed out behind the wheel of his vehicle. I believe the joint recommendation is appropriate in this sense, given the defendant first and foremost is taking responsibilities for his actions. While this is a serious level offense, I believe the sentence will provide Mr. Hess the opportunity to take advantage of whatever programming is available in the jail to help tackle that alcohol abuse problem that seems to be plaguing him. But it would also accomplish the goal of general and specific deterrence. First, by specifically deterring Mr. Hess as he has reached the highest level of felony OWIs in Wisconsin. From here on out, any subsequent conviction will carry a mandatory minimum of 4 years of initial confinement.
I'm going to stop you. He's reached that, but what is his actual number?
This is number 10, Your Honor.
This is actually number 10.
Yes.
All right. Now you may continue slower.
Thank you, Your Honor. But secondly, we also want to generally deter the public here. Driving under the influence will be taken seriously, and these offenses can carry a mandatory minimum sentence. The need to protect the public will also be accomplished here, since the defendant will be confined for initial confinement of a period of 4 years. The ultimate goal here should still also be to reduce the chance of recidivism. As such, I would ask the court to adopt the joint recommendation. Thank you.
Mr. Flisky, argument, please.
Thank you, Your Honor. When I first began representing Mr. Hess, he was very upfront about the need to take accountability and responsibility for this matter. The fact that he was willing to do that from the outset on such a serious case, Your Honor, tells me that he very much understands that this was a significant and severe error on his part. He has regretted it deeply. He's indicated that to me essentially every time that I've spoken with him. He deeply, deeply regrets the decision that he made. He's made no excuses for it. To me, I don't anticipate that in any statement he would give to the court, he would make excuses then either. He acknowledges that he did wrong here. This is something that never should have happened. It happened, but he is here today before the court to take responsibility and accountability for his actions. I would note very thankfully in the fact pattern here in the complaint, it seems that there wasn't any injuries nor any damage to any property. This was not the result of a crash, either with another vehicle or a rollover in a ditch. Mr. Hess was found unconscious in his vehicle, and later investigation indicated that he was operating it while intoxicated. I bring that up, Your Honor, because I think here the mandatory minimums are appropriate given the nature and circumstances of this case. I would note that the last conviction Mr. Hess had for this type of offense was back in 2016. He's indicated to me that for a significant period of time, he was sober. He was doing well in the community. It's my understanding that for the most part, actually, he's been a resident of Montana rather than Wisconsin these past several years. He advised that when he moved back to the area, he had some difficulties in adjusting to probation here. And what I mean by that, Your Honor, is that it sounds like he had several agents who were appointed and then were either transferred, quit, somehow removed.
We've had a lot of change.
There's been a lot of change, Your Honor. And I think that having that in the short period of time that Mr. Hess was in here, unfortunately, may have negatively contributed to the situation. I don't say that, Your Honor, to, again, excuse Mr. Hess's actions. They're not excusable, but simply to provide some context here that there were some supports that Mr. Hess could have received that unfortunately he wasn't able to get access to. I think overall that this is an appropriate agreement. I certainly think the public is protected. Mr. Hess was revoked on these. Of course.
You guys both like to speak a lot fast.
Of course, Your Honor. Mr. Hess was revoked on this matter. He is currently in custody at Dodge, so he will remain in custody in there for some time, to my understanding.
Is it 4 years?
I believe so, Your Honor. I think that the statutory minimums here, what's recommended is appropriate. Again, given the nature of the offense here, this is certainly a very serious matter, but looking to the lack of injuries, looking to the lack of damage, looking to Mr. Hess's willingness to be upfront before the court and say, I did wrong, I will take my punishment, I will move forward, and I will improve and not have this situation happen again. I think overall this would be an appropriate agreement. I will lastly add, Your Honor, that Mr. Hess is advised once he does get out of custody, he does intend to relocate back to Montana. That's where his family, friends, support group are located. It sounds like that he was doing quite well when he was in Montana. He advised that he was employed with the company True North Steel. I may be misremembering our most recent conversation regarding them, but it sounds like that may be an opportunity available to him should he return to Montana as he is planning. I think the programming available in the jail for Mr. Hess, in prison, excuse me, for Mr. Hess will be sufficient to address the ongoing substance use issues that he has been dealing with, and will hopefully provide a framework for him to avoid ever having this happen again and to never appear before this court or frankly any other court for this offense or any offense ever again. Overall, Your Honor, I think that the agreement here between the parties is appropriate. I would ask the court to follow it. Thank you.
Thank you. Mr. Hess, can you please, if you would like to provide a statement to me, this is your only opportunity to do so. You don't have to, but again, it's your only opportunity to let me know anything you want me to know.
The other thing I'd like to state is you said I'm very happy that no one was harmed. That the only person that is truly affected is myself. My intent was never to harm anyone, and I would like the courts to understand that. So that's basically all I'd like to add. Thank you.
Thank you. Mr. Hess, I believe that it's never anybody's intent to harm anyone when they operate a motor vehicle while under the influence and something happens. No one wants that to happen. Everybody, quite honestly, anyone who drives behind the wheel while intoxicated believes, I'm not drunk. I can handle it. I'm just going 6 blocks. I'm not going that far. And then something tragic happens. The court has to first look at the seriousness of this violation. This is an OWI 10th. This is very serious. This is so serious that 9 other times wasn't enough for you to understand and to learn not to get behind the wheel. 9 other times. Your blood alcohol content was 0.323. 0.323. It's 0.08 in Wisconsin to be above the legal limit. 0.323. That's extremely high. And you were passed out in front of the wheel, not just sleeping. There's a difference. So this is extremely serious, and thank God, thank all of the spirits, and thank everything that we can that no one was injured or hurt, and that includes you, because we've had other situations in which it has been extremely different, and we've had to bury people or had people in wheelchairs for the rest of their lives. So this at least had that positive where nothing happened. I have to look at you and your criminal record. I do take into account, and I see that it has been 10 years, give or take, since your last OWI. However, the 9th still wasn't enough. It wasn't enough to say, all right, Mr. Hess, I'm not getting behind the wheel. I'm not going to put anyone at risk, and that includes me. I'll walk home, even if it's 10 miles, instead of getting behind the wheel and driving. And I have to look at the community and protecting the public interest here and the public in general. Because this is an OWI, it's serious in and of itself. But then when you tack on, this is the 10th, it makes it extremely more serious, because you can only tell someone so long and so many times, stop, stop, stop. Hopefully this was it. Hopefully this was the last time and you're not going to do it again. And hopefully no one ever becomes injured or killed while you're behind the wheel. With regards to this matter, you do have 4 years and some change to sit from your revocation. You were revoked off of extended supervision. I was toying with what to do if I follow the recommendation. But you have 4 years, and if the court follows the recommendation, that's 8, because the court, this is definitely a consecutive sentence. So I will follow the recommendation, 4 years of initial confinement consecutive to any and all sentences you are serving. You are not eligible for any earned release programming. No earned release programming. 5 years of extended supervision. You are not eligible for earned release programming while on extended supervision, because if you are revoked off of extended supervision and you still haven't learned your lesson, shame on you, shame on me. So with that, on extended supervision, absolutely no alcohol, no possession, no use. No bars, taverns, liquor stores, casinos, no establishments that have the primary purpose for the sale or service of alcohol, no beer tents, nothing that would serve alcohol. Regular alcohol testing, regular, that means you will have regular testing, and quite honestly, when you are released from extended supervision, the court will order that you must have a buddy bracelet or similar, meaning that you are wearing a bracelet that continuously tests your blood alcohol 24/7 for the first year while you are off of extended supervision, and then regular alcohol testing. Definitely absolute sobriety, AODA assessment and all follow through. Mental health assessment and follow through. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. With regards to the OWI 10th, this is a doozy. The court is ordering $8,446 in fines and fees plus a $10 blood draw fee. Revoking your driver's license permanently. No chance of getting another driver's license. The court is ordering you provide your DNA. The prison will make sure that they have it. This is not something you can have it expunged because it is so serious. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, but the court will issue a warrant. You could sit an additional 6 months in jail. Mr. Vila, what is the court missing?
I don't think you're missing anything, Your Honor, not from my perspective.
Mr. Felicki.
Nothing further. Thank you.
All right, thank you. Then we are adjourned.
What began as routine status updates ended with a sobering reminder of how seriously the justice system treats repeat impaired driving. The judge's sentence, years of confinement, extended supervision, permanent license revocation, strict sobriety monitoring, shows a clear priority: protecting the public after repeated warnings failed. This case underscores a broader reality. Rehabilitation opportunities exist, but they shrink with each subsequent offense. It's a stark example of how the legal system balances second chances against community safety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, especially whether you agree with the sentence, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.